Good evening, everyone.
Good evening.
Okay. So we have a special person moderating today. Hi, Bernice.
Hi, Juliana. So I'll just go, it's 4:30 already. I would start now. So my name is Bernice Asen, and I will be the anchor for today. I'm a lawyer practicing in Lagos, Nigeria. So I'll go ahead to introduce the program. So JIIPCC Intellectual Property Mentorship and Internship Program is a quarterly program for students, young professionals, and enthusiasts across Africa. Mentees are afforded opportunities to access valuable advice, training, network, mentorship, internship, discussion forums, industry updates, and resource materials from experienced mentors. This program seeks to encourage continuous training, development, and evolution in Africa and around the world. You can watch our videos by searching JIIPCC on YouTube and Facebook using the hashtag JIIPCC The objectives of this program is to provide easy access to quality professional guidance, training, and resource materials for students, young professionals, and enthusiasts in Africa. Also to facilitate dialogue and network among experienced and less experienced practitioners and stakeholders, to transform mentees into mentors and leaders for the next generation of mentees. And lastly, to facilitate further mentorship, internship, and scholarships with job placements for mentees. So we also have, to the announcement, we also have a 30-minute private one-on-one mentorship session with your favorite JIIPCC mentor. So you can get hacks, secrets, life lessons, and direction from any of the mentors that you've seen over the period of time. So you can, fill in the form, as I'm sure that all of you have seen. Would you share that? Fill it so that you can, be allocated time to speak to any mentor of your choice. So we are also encouraged to put on your videos because we are streaming live, and also edit your name on your Zoom account so that we can actually take a record of your attendance. So every group has 7 minutes to present. So we'll start with group 1 for their presentation. So we are giving you 7 minutes to make your presentation. Group 1, over to you.
Sorry, good evening. Good evening, can you hear me?
Yes, we can hear you.
Sorry, good evening. The person presenting for group 1 isn't been around now, like not online. So I'll call him to come online.
Oh, okay,
so
then
maybe present while.
Okay, we'll just move to group 2.
Thank you.
Anybody for group 2?
Good evening. My name is Olmegola Damlola.
Good evening.
I'll be representing group 2. However, the person to share the screen, I don't know if he or she Wow. The person is not here.
But you can proceed without the slides.
Okay. Okay. Once again, good evening. My name is Olmegola Damlola. I'll be representing group 2. Our topic are 1, businesses that maximize patent, advantages of IP management and IP ownership in businesses. We started off to define what patent is. Patent according to, okay. Oh, wow. Thank you very much. Okay. According to Whiteboard, patent is a document which describes a specific invention, contains a claim which creates a legal right for the inventors, alerting that the invention can normally be exploited only with authorization of the owner of the product. Also, I would like for us to understand that patent is more like an exclusive right that is being granted to an inventor for a new process. Maybe, let's say it invented a new thing, yes, that right automatically goes to him so long as it registers it. So we should also understand that patent only does not have to do with just new invention. It could be an improvement. When I say an improvement, it could be a form of, oh, a particular thing is already in existence. Someone else just brought up something to improve the thing. Let me use an example. Let's assume that, okay, a company, right now we have various companies that produce pens or Bible, but then if I as a person then come up with the idea that instead of just having just plain pen, we could have a pen that also has what's this thing called? A corrector. Can everybody hear me?
Yes, we can hear you, although there's a stop.
Yes, we can.
Okay. I could decide that let me produce a pen that has a correcting ink too. That's an invention. That's an improvement. Okay, thank you. That's an invention. That's an improvement to something that has already been done. It is an improvement, not like it has not been done before. So that being said, I would like to. Why do patents need to be protected? The basic reason why patents need to be protected is in order to stop or prevent a third party from infringing on their rights. What? Yeah, out of the book, I would like to state that there are 3 types of patents. We have utility patent, we have design patent, we have plant patent. Design patent basically protects new designs, new original designs of an inventor. Let's say, just like the example I gave now, the pen and the corrector, the way the pen would be, the way the pen and corrector would be placed, the design, it could fall under patent design. Also, utility design protects new invention, basically. Then for the plants, so if it protects plants that are capable of reproduction. What else? For something to be termed as patent, it has to be capable of mass distribution and production. What we're trying to say right now is that for something to be classified as patent, it has to be a new invention. It has to be something that, the invention is not obvious. It's capable of mass production. Every other person can use it. It's not something that just one particular set of people can use. It's capable of mass production. Okay, is it here too? Yeah, how long does a patent last? Okay. How long does a patent last? A successful patent will normally last for 20 years from the date of filing. Then the principal patent law in Nigeria is the Patent and Design Act of, and then the advantage of, okay, IP management means effective management of an enterprise IP portfolio to protect the company's database and then disease risks, enhance policy with global legislation. The basic reason why every company and every person wants to protect their IP is in order to not, in order for their work not to be exploited by somebody else, there has to be a proper database and account for everything that is being done with the IP. Then intellectual property management software is used by businesses and IP law firms to manage and protect invention, patents, copyrights, trademark, license, royalties, grants, and other intellectual property legal rights. And the strategies for IP management, in order to put all manage and maintain IP, you have to put policies on how IP are being acquired by a third party, how it can be explored, how the company will continuously monitor the IP in order for it not to be breached or infringed by somebody else, and then the process of enforcement of the IP.
You can round up now.
Advantages of IP. Okay, it will be in order to put the company out there. Another one will be for to make to enhance export opportunity for the company, then to turn ideas into profit would be okay. Then anybody that creates it. But for IP, it is quite different. The legal position is dependent on the creation of how the work is being done. If I was to be under an employment with a company, any IP I protect or anything I do for that company will be for the company, so long as I'm under an employment agreement with the company. After my termination, I will not have any rights to it. But if I was to be an independent contractor, it would be a different case entirely. I would own the right to my IP. But except where there's an agreement between the company I'm working for and myself, then they can then own the IP. Then if it's a third party, somebody that is just interested in making use of my work, can come to me, I license it or I assign it, whichever way, then that person can own a right to it.
So you can round up now. Your time is up.
Yeah. That's it. Thank you very much.
Thank you. So group 3, you have 7 minutes. Is there anyone for group 3? Since there's nobody, we'll move over to group 4.
Yeah, it's someone. Good afternoon, ma'am. Good afternoon, ma'am.
Good afternoon. I can hear you.
There's someone. Let me check if he's online. There's someone that's meant to do the presentation.
Okay, but let group 4 continue if they are ready, and we'll.
No, good afternoon, ma'am. Group 3 is ready.
Okay.
Okay. Please, can you hear me clearly, ma'am?
Yes, we can.
Okay. All right. A pleasant evening to everyone. My name is Olusheye Abu, and I'm representing Group 3. And our topic for this week is introduction, intellectual property and business. Intellectual property and business. And by way of start, I would love to, just basically introduce what intellectual property is. I know most of us are familiar with it, but notwithstanding, intellectual property is the creation of the mind. It's what the human faculty can produce. It's the property associated with the intellect. So if a musician sits down and then writes a song, that is the product of his imagination, of his mind, and that is his intellectual property. If an artist sits down and paints something or draws something out, that is the product of his mind. So specifically, we'll be looking at three major aspects as we've been given. The first one is to see how copyright affects business. How copyright affects business. What role does copyright as a branch of intellectual property has to play in businesses? The second is to see the importance of IP valuation. Is to see the importance of IP valuation. The third is franchising and intellectual property. So, what really comes to mind in considering the role of copyright as a branch of intellectual property and how it affects business is what is business itself. One should, understand what business means itself. So business basically is the buying and selling of goods. It could also be said to be the trading or rendering of services in exchange for money. So it is safe to say that businesses generally are set up for profits, for profit making. Businesses are all about money making. They are all about making money. So how does copyright now affect business? Now, intellectual property, I must say, is divided into two categories. Firstly, there is copyright and there is industrial property rights. Now, copyright deals with, according to Section 1 of the Nigerian Copyright Act, copyright deals with 6 categories of works: musical works, literary works, artistic works, cinematography, broadcast, sound recording. And for industrial property rights, that is where we have the patents, we have trademark, we have industrial designs, and all that there is in that regard. So how does copyright now affect business? Now, every business thrives on innovation. And copyright protects the innovation of artists, musicians, and writers. When I started, I made examples of a musician who sits down to compose a song. I made an example of an artist who draws a person or who draws an object. Now, these people are, according to Section 6 of the Nigerian Copyright Act, they enjoy the exclusive right to reproduce, to adapt, to publish, to perform, to translate, and communicate, publish these works exclusively. They have the ability to do that, without being questioned. And one can readily say that an artist who does that for a living is in the business of how do I say this now? What I'm trying to say basically is that anyone rendering service as a musician who has been invited to sing at an event, an artist who has been engaged to make a portrait, to draw something, to draw an object or something, is in the business of that thing. And according to Section 6, he or she enjoys the exclusive right to do as he pleases with the particular thing he deals with. So copyright encourages, it helps these categories of persons in this line of businesses, as I have given the example, it protects them, it protects what they do, it protects their businesses, it shields them against infringement, you know. Another thing is that copyright, another effect of copyright on business is that copyright can potentially result in costly lawsuits. You know, where a person who is a musician or an artist, as I have been using, is ignorant of the fact that he or she enjoys a particular right over what he does in his line of business, he or she stands the risk of infringing on other people's works. He doesn't even know he or she owns a right. So he cannot even understand that others have rights in that regard. So he stands the chance to, you know, infringe on other people's rights, other people's works in that regard. So a good knowledge of copyright or intellectual property should a business owner, you know, against infringement, against infringing on other people's works. So every business should therefore make it a point of duty to ensure that they protect intellectual property. They protect their intellectual property. It is only when it is protected that they enjoy exclusivity. They also get to maximize their profits. However, apart from a business protecting its intellectual property, it should not infringe the intellectual property of any business or individual. Where there is an infringement, a lawsuit may follow, and time and money will be wasted.
You have
So,
2 minutes.
2 minutes more. Okay, thank you very much, Ma. So, moving on. We kept a case study here, and that was the situation where the Federal High Court gave a judgment with respect to a dispute, a copyright infringement dispute, between a plaintiff who approached the National University Commission to endorse a program, a TV show tagged University Challenge. The concept of the show was an educational television quiz program, which was to be contested by Nigerian university students. However, rather than endorsing the program, the NUC approved a similar show tagged Zen African Challenge, and this show was sponsored by the second defendant in the particular case, which is a telecommunications network operator. The plaintiff brought a claim before the court, and the exact show was an infringement of its intellectual property in the show. So, relying on the registration of the US show proposal document with Nigeria Copyright Commission as evidence of its exclusive copyright ownership, the plaintiff brought a claim before the court that the exact show was an infringement of its intellectual property in the UC show. So, another thing is that copyright, when it is registered, it helps a business owner. Just as you've seen in this particular case. So, the court found that there were factor similarities between both the shows which infringe the plaintiff's copyright. The defendants were therefore held liable for infringement of the plaintiff's copyright in the UC show, particularly the right of reproduction and adaptation. So moving on, we'll move on to IP valuation. Now, intellectual property valuation is the process of assessing the monetary value of your IP asset. Now, it's just evaluating what contributes IP in your business, and also evaluating the value that these assets have. So IP assets are set of intangible assets which are legally protected and can be legally enforced. Assets such as copyright, patent, trade secrets, and others. Now, there are three basic methods of IP valuation. There is the cost method, the market method, and income method. The cost method looks at what went in the production or in the development of the particular IP asset. And then this is used in evaluating or in valuing the importance of the market method. The market method is based on a comparison with the actual price. So the particular prevailing price of the particular IP asset is used to value the asset, to know its value. Another one is the income. Now, this is a projection of the possible income, the possible income to be generated from the particular IP asset. So there are factors influencing IP assets, ranging from the standard of value, the premise of value, the nature, scope, and strength, validity of the underlying IP assets, time and date of valuation, legal tax, financial or other business circumstances. So IP valuation, the standard of value that, like the as I discussed, the market value, the market system, the cost system affects the valuation of IP assets. The nature and scope of the particular IP asset itself also affects the IP asset. Another thing is the importance of IP valuation. IP valuation helps to communicate the value of its IP assets to capital markets during transactions. In mergers and acquisitions, a business who has done IP valuation, enjoys an upper hand. He has an edge. The business has an edge because the business knows the value of its assets and is able to negotiate properly. It also helps the company or business to know its value. IP valuation is important for internal management of IP assets and strategic financial capital raising. So another thing we have to touch on pricing. My time is off. Okay. Thank you, Ma. Thank you, Ma, for the opportunity. So in conclusion, IP valuation and franchising, which is the last thing we're supposed to talk about, are tools which can help a business to thrive properly. Franchising just involves the extension of a business IP what's it called, rights, through another business in order to enjoy more profits, in order to enjoy more acceptability and more acceptance in the society. So there are types of franchise as indicated in our slide. So in the words of Sandra Eke is an intellectual property expert and an associate of a law firm, a reputable law firm in Nigeria. She says intellectual property rights are the main source in trade in a franchise. They avail franchises an opportunity of business expansion while simultaneously making profits through the collection of fees or royalty payments from their franchises. The nature of a franchise exposes the franchisor to high risk of possible misappropriation of its trade secrets, misuse of its brand reputation, goodwill, and other intellectual property rights. They are very crucial provisions that must be inserted in a franchise agreement to ensure that the IP rights of the franchisor are adequately protected. And in this regard, it is advisable for a prospective franchisor or franchisee to retain the services of an IP lawyer before venturing into a franchise agreement to ensure that all requisite bases are covered. So thank you very much for the time given.
Thank you.
This is the presentation. Thank you.
So move over to group 5. Group 5.
It's just group 1 to 4. It's just 1 to 4. So I think it's group 1 that's not presented and
left. Okay. So group 1, are you ready now?
Yes, ma. The person presenting is around. Yes.
Okay.
We'll present it now.
Group 1.
sorry, what group are we waiting for?
We're waiting for group 1.
Group 1. What about group 4? Has group 4 presented?
Sorry. Can you hear me now? I was talking, I was muted, I didn't know. Can you hear me now? I'm from
Okay,
group 1.
sorry.
Yeah, go on.
Who is the lady that wanted to present just now?
No, you
Yeah,
called
group one.
me before, so I
Can you hear me
said
now?
I'm here.
Okay. Sorry, I can hear both of you. So what group is presenting now? 1 or 4?
1.
I think one.
1.
So can I go on, ma?
Yes, you can.
Talking about 3 highlights. That's businesses that maximize trademarks, how businesses can export IP, and importance of research and development in intellectual property. So we started by evaluating that trademarks in the first. It says that trademarks, a lot from time to time, some are not aware that there's a kind of weak concern which denies them the activity of seeking protection of their trademarks, as well as the value these trademarks can be to them, can offer them, sorry. So we went ahead to define what trademarks are. So trademarks are defined as any word or symbol that identify a particular goods or services originating from a particular source. So generally, trademarks are distinctive marks, which can be word marks, symbols, slogans, product name, brand names, or anything that distinguishes product A from product B. Helps to ensure easy identification of a product and helps to distinguish one product for the other. It's also very essential for any company or brand that also loves to, play it, also stay safe in the competition, as well as it affects the goodwill of a business. So we also talk about businesses that maximize trademarks. You say in our slide, you said today the use of websites and social media in advertising goods and services is widespread amongst businesses of all sizes. The businesses that can unknowingly affect their trademark rights with a simple social media post, because any such post will automatically qualify as used in commerce. So this is what's saying is that since trademarks are basically affect products and services which are in quotes in commercial sense, which are used in for commercial purposes. Most times when these rights are created, some companies, give loose protection, loose guard to their IP rights, and most times a lot of third parties infringe on the intellectual property, on their trademarks. And with the advent of digital mediums, digital streaming, digital media, as well as other innovations in technology, where you have the internet, where people do businesses in the internet, you have digital marketing brands and businesses doing things in the internet. It now gives more room where a brand can infringe on the trademark of another in a very simple manner. And this, with weak protection, it can actually affect these businesses that own these trademarks adversely. Now we talk about how can a business, we went ahead to ensure, to continue by saying, how can a business export IP? So intellectual property, actually, it's a creation of human mind that has commercial sense in it or when exploited. And the exploitation of intellectual property can come in different forms. It can come through merchandising, it could come through franchise, it can come through licensing, it can come through assigning, it can come through making reproduction of your works, or making distributing your works, or making copies of your work in areas of copyright and other things. So we came to highlight that IP exploitation is the protection and exploitation of intellectual property protected and exploited in the IP jurisdiction it originates from in another IP jurisdiction. That is the target jurisdiction. In essence, this is saying that one is using his intellectual property, he's transposing the intellectual property from one jurisdiction, that's from one locality, from one state, from one country, from one county, from one local government to another, right? But most times this is IP exploitation is usually on offshore basis, where you from one country to another. So IP rights are territorial. So you can
You have
if
2
you have
minutes more.
protection in Nigeria, you have to actually seek protection in Ghana for your works to be protected, unless you come through the international framework. So the reason why we actually talk about how can the business export their IP is actually talking about the considerations to look at when exporting your IP, as well as saying that, okay, since you can take this intellectual property from one jurisdiction to another, you actually have to do a bit of due diligence to actually protect your work from what in the foreign jurisdiction you want to operate in. And if we continue, we just went ahead to highlight the different ways intellectual property can be intellectual property when exporting your intellectual property, how you can actually protect them and guard them. So you talk about the national routes, the international regional route, and the international frameworks. So national route, you talk about your national laws. In the regional route, you talk about the regional laws, regional frameworks. You know, for example, the intellectual property conventions, treaties, you know, that are binding African countries together. In international frameworks, you talk about the Berne Convention, Madrid system of registering of trademarks. You talk about Paris Convention and other conventions. Then you go ahead to talk about other available means. Now, other available means, that's where you talk about merchandising, franchising, licensing, and assigning. So you have licensing where you license the use of your intellectual property to a third party for a fee. That is for a licensing fee. You own the intellectual property, you just license the use or the exploitation of that intellectual property for a specific period of time, and consideration is offered in terms of a fee for the third party to use your intellectual property. Then you talk about merchandising. This relates to products and using your IP in products and services. So merchandising is defined as assigning an arrangement or agreement where trademark designs, artworks, fictional characters, real personalities, and other distinctive signs are licensed in relation to products and services. So you can actually license.
You can round up now. We can't hear you anymore.
Okay, I think he's having network issues. So maybe we can hear from the next speaker. And when he's able to figure it out, we'll continue.
Okay. So move on to group 4.
Yes, group 4 is ready.
Okay.
Can you hear me?
Yes, we can.
Okay. Good evening, everyone. My name is Raji Sekinat, and I'm representing the Intellectual Property Group 4. And the topic for us is IP for business. And under that, we have businesses. We'll be taking businesses that maximize industrial design protection, importance of IP licensing, importance of trade secrets to businesses. Okay, before I start, I'm going to paint out 2 scenarios. Actually, they are like real life scenarios, not like a fiction. So the first one, oh my God, sorry, I forgot to share my slides. I'm coming. I want to share my screen. Can you see my screen? Hello?
No.
Maybe. Sorry, is any group 4 member here? Is it possible for you to share the screen? I'm having issues sharing the screen now.
You can go on without slide. It's possible.
Okay.
Okay.
Can you see the screen?
Yes, we can now.
Okay. Okay, so I'll be starting at the senior role. I'm starting with Coca-Cola. So as we all know, Coca-Cola is well known for protecting their trade secrets. Like they literally no one knows their unique ingredients for the flavor of their Coca-Cola. Even the likes of Pepsi, Big Cola, and any other soft drinks, they've been unable to get the ingredients of Coke. So you can see that they have a very good trade secret protection. Also, the shape of the Coca-Cola, it already has this unique shape that when this unique shape and color, as well as the design they used to write the Coca-Cola, the italics design. So normally, if you are like staying in a very far distance and you spot a Coca-Cola bottle, you don't need to see what is written on it before you know that this is a Coca-Cola bottle. So Coca-Cola is a very good example of a business that has maximized their trade secrets, industrial design, and trademark. And there's a case of Coca-Cola and Pop Cola. So in Pop Cola, it's a drink. They took the design, the color, the design of Coke, and it's, to me, it's a way of passing on, because personally I found myself in a situation. I went to get a drink and I didn't realize I was drinking something else until I was done with it. When I let me even just check this bottle, I just realized I was drinking something else. That's that popular. So that's like this is a very good example of passing off. So let me go into the we also have Vaseline and Vaccine. So businesses that maximize industrial design protection. So what is industrial design? Of an article. So it may consist of the shape of a product, like I said, the Coca-Cola bottle shape, the patterns, the lines and color, like the red color for Coca-Cola. So it protects the aesthetic of a product. So the key word is aesthetic, the appearance of a product, not necessarily the product itself. So some people they've thought of if they'll sit and they think of a means, so how can we attract people to our product? Like when people see this our product, how is it going to differentiate us from other products? What is that unique thing about our product that's going to attract more customers compared to our competitors? So this is what Coca-Cola are able to do. They are the shape of their bottle. If you can permit me to even say, like some people even use the word Coca, like some people they don't describe someone that has like I don't know, like a figure eight body. They usually say you have a Coca-Cola bottle. So this even shows how much that shape has been attributed to Coca-Cola. So like I said, we have examples of businesses that okay, before I go to that, industrial design, it's like I said, the key factor is attracts us to products. It attracts us to a product and make us prefer one product to another, and it's essential for the creation of product that satisfy the user's need and preference. So industrial design applies to a wide variety of products such as packages, furnitures, architectural products, buildings, a lot of things. And I said, like for example, I said in the fashion industry, there are a lot of people who are into designing clothes. So like Louis Vuitton, for instance, Versace, you can't wake up one day and say, oh, I want to design a coat and decide to use the design of Louis Vuitton. They're going to sue you because you are going to be infringing on their industrial design. So we also have manufacturing industry. Just like this one encompasses a lot of industry, people that basically manufacture either foods, equipment, kettles, chairs, a lot of things. So I want to say the importance of one of the importance of this industrial. Okay. So I'm going to importance of IP licensing. So licensing is a major aspect of intellectual property. So it is one of the ways of commercializing your IP rights. Other ones that we have assignments, we have franchising. But licensing, to it enables you to give someone the right to use your IP rights, but not transferring your IP rights, but giving the person the permission to use your rights subject to payment. So it's a way of generating income for business. So businesses that involve in that maximize IP license, it enables them to get the value of their work. It's like it gives them the control of their work. Like no one can mishandle their product, because before you can even decide to use their IP rights, you have to get the license. So that way they're able to control the activities of their products. So it also gives respect to the product. And also there's something about IP license. Sometimes a manufacturer might manufacture a product. Well, though things happen, maybe the manufacturer becomes bankrupt, or let me say the person does not have money again. But because you've already licensed others to use your IP rights, that way your business keeps going. So and that way you're even still making money, because these people, as they're using your products, they're also paying you royalties. Royalty is like a fee that comes in licensing. All this music industry, how they make their money, they build through this collective management organizations who get royalties for them, they make money. And one of the importance of IP license, it makes your work to be recognized internationally, not just locally. So your works get to go over, not just within your country, your local environment. Then we have the importance of trade secrets to businesses. Trade secret, like I said, Coca-Cola, not necessarily because of their trade secret, but one of the main reasons they are still in business over these years, because they have been able to protect their trade secrets. No one knows. There's even a rumor that it's just two people that know about their trade secret, and even those people, they don't even know who and who are they. They don't just know that, okay, I know, but they don't know the second person. They don't know themselves, basically. So this trade secret has enabled Coca-Cola to be able to be in the market. So it does not require registration. What makes it a trade secret is the fact that you don't disclose it. Coca-Cola it's the best example to.
Oh, so you can round up now.
Okay, so we have so the importance of trade secrets, basically, it makes you to be competitive. It puts you in markets, it puts you ahead of your competitors. Okay, so it also trade secret gives commercial value, because it gives a protection for other IP rights. If your trade secret becomes known to the public, it can tarnish your other rights, like trademark, for instance, even your industrial design. It makes them if today people get the unique recipe of Coca-Cola, I feel like they won't be in business again, because a lot of people will start copying them, and obviously even sell it at a cheaper rate, just because they want to just push them off the market, especially the fact that they've been there for so long. So in summary, I don't really have enough. Like I said, yes, grants the owner a beneficial edge over the competitors, does not require registration formalities. It has protection guarantee for an unlimited period, like it's forever. So far, you don't disclose it. So basically, the importance of IP rights, businesses should not neglect all this IP, because it basically puts them in business, and most importantly, it makes them get incentive. It makes them make money out of this, their right, and not just protecting their product, but even making money out of it. So I don't know if I'm supposed to say the question we have, but the question is from Trace. Let me just say the question now.
No,
Because when we're sorry.
I said I don't think you should bother about that. You should just round up and.
Okay. So that's all for. Thank you for listening. Thank you.
Hello?
Yes, I'm done.
Okay. Thank you, everybody, for your presentation. So we'll go over for today on intellectual property for businesses. We have two mentors, Mr. Amala Umeike and Mr. Aloko. Folarin.
Well, how do I stop sharing? Okay.
Ben, can you hear me?
I can hear you.
Please let the group one guy just finish since he had internet issues.
Okay.
It's possible for him to just round off.
Okay. Group
Thank
one.
you. Is he still here? Anthony. Okay. Maybe we just go ahead since his internet is fluctuating.
Okay. So we have Mr. Amala had to leave, but we have Mr. Folarin Aloko. Mr. Folarin Aloko is a legal practitioner and partner in the firm of Truman Rockwood Solicitors, where he provides advisory and consultancy services to companies and a wide range of creators, users, and startups. Mr. Folarin is a director of the Intellectual Property Institute Nigeria. He is the chairman board of trustees of the Intellectual Property Lawyers Association of Nigeria. Mr. Folarin is also a member board of trustees of the Sports Lawyers Association Nigeria, as well as a member of the board of Nigeria Digital Chambers of Commerce. Mr. Folarin is also a board member of Songwriters Association Nigeria with background in ICT hardware and data forensics. Mr. Folarin has led legal teams to champion the consequential impact of public interest litigation in the IP space since 2012. Mr. Folarin is also a consulting mediator with commercial intermediaries at the ADR firm based in Lagos and Abuja. He's a thought leader in Nigeria's innovation, technology, and intellectual property and entertainment space. We're pleased to have you in our midst. Over to you.
Hello, good evening. Hello, good evening, everyone. Thanks for that rousing introduction, Bernice.
Yes.
Bernice is my personal person. Good evening, everyone. Thanks, Juliana, for the opportunity. I hope, please forgive me for not coming up. I've had a very long day, and I'm just managing on one corner of one place like that. So kindly forgive me. I hope I'm forgiven. Thank you very much.
Yes, you are, sir.
Thank you very much. Don't worry. Subsequently, you will see my big eyes and big head. So I would like to say it's always a pleasure to be here, Juliana. Right here with me in the office, interestingly, is Mr. Formi Johanna, who is a friend of the house. He's laughing. But I'm happy to see I recognize some names in the chat. I see Mr. Femi Josu. I see Shukura. Of course, Bernice is a friend of the house, my personal person. Let me see. Yes. I would say congratulations to this new team or new batch of mentees or interns. It's this is it's going to be an interesting ride. I think you're making history. So congrats. Please take the conversations very seriously. There's a huge learning opportunity here, a huge networking opportunity here as well. And Juliana does have a knack for bringing together conversations that that are very timely, very topical, and that one can learn from both as a student and as a practitioner. So it's not just about an academic. It's not an academic conversation per se, or it's not just an academic conversation, but I always find that there's something to learn. There's always something to learn for everyone. So I'm supposed to respond to the presentations. I listened to all the presentations. Very good work. Very good work. I made some notes, but I don't want to drag everybody on a merry-go-round. So I will abridge my notes and probably just speak generally to the theme of the conversation, which is intellectual property for business. And maybe my starting point would be to issue a disclaimer that I will not be speaking about intellectual property for churches or for mosques. I'll restrict my conversation to intellectual property for business. Yeah, I think we had, I was part of a conversation just today, and we talked about, I mean, I heard some of the things we talked about being echoed here. It was the conversation around IP valuation. So intellectual property is property. I think that's the first, that should be the starting point for, you know, any conversation. Is property. Property has value. You know, there's always this argument that maybe value is a relative or is a subjective phenomenon, but we all know that in order for society to function, at least on an economic, for the economy to function or for transactions to take place, you know, one must have an objective basis for determining value, you know, and we call that objective means of value, we call it currency, or we call it money. And money gives us, so we say XYZ is 10 naira. That cost of 10 naira, you know, is a value that is accepted or acceptable. Or let's say it's 1 Bitcoin, you know, 1 BTC, or, you know, and so on and so forth. So currency really is what we measure value by, you know, economically. And so intellectual property is property. Property is anything that has value and can be owned. And IP is not just a legal phenomenon, it's both legal and economic. So it's viewed from the prism of the lawyer as a bundle of rights, etc. And it's viewed from the prism of the economist as an asset or as a liability. You know, and in the economist sees, yes, the economist sees just two things. It's either an asset or it's a liability. It's either something that adds to the net worth of the company in terms of how to pardon the secular use of value, how valuable the company, you know, that organization is, or it's something that takes away from, you know, the value of the company, in which case it's a liability. You know? So that's the prism of the economist. And so IP is property. And of course, if it is property, then property can be stolen, property can be traded, it can be transferred, it can be assigned, it can be lost. Like in the case of Maggie has almost been lost. Xerox has been lost, almost lost. You know, in many countries, we tried recently to fight for the name back. Panadol in some countries has been lost. So property can be lost, just like IP can be lost like real property. So talking about the significance of IP to businesses, I think this conversation is very topical for the age that we're in. You know, in the information age, or in what is called the decade of the creator, IP is like the foundation or the superstructure, the substructure on which the entire it's not just the foundation now, but rather it's not just the entire industry, but the finance or the economy of the entire industry is built. So it's operational, it's the basis for the technology, it's the basis for the economy, it's the basis for, you know, for the operation. And what do I mean? For the technology is essentially driven by IP. You know, we did a case study of was it Disney today, and Walt Disney has a very robust IP portfolio, perhaps one of the most robust in the world. In the portfolio, you have patents for a bunch of things, including streaming technology, photo editing, video editing, animation editing. You know, you have trademarks centered around their titles, their various titles. You have copyrights also centered around different titles and characters. They have the Star Wars IP, you have the Marvel IP, you have the Snow White IP, you know, and so on and so forth. And this portfolio has allowed Disney to shift from being a media company, a production company, to being a distributor, you know, through streaming, of course, the Disney Plus platform. So, you know, you can leverage on your IP. A business, I mean, not every business is Disney, even though, you know, we would all want to be Disney, but yeah, it just provides a perfect illustration for the ability to use IP or leverage on IP to transition from one industry or one sector to another. And if you look like movies like Black Widow and co, they understand how to use, or they have tried anyway, to use their IP to position themselves in the new markets that they're shifting to. If you look at the portfolios of other, you know, big production companies, let's say we're sticking with production, you find also a similar trend. There's a huge reliance on intellectual property. One field that I would have expected to see a more aggressive use of intellectual property in Nigeria is the fintech space. You know, but I'm so surprised. You have a Kuda, you have a Kudi, and I'm wondering, what are these guys doing? You know, Kuda, Kudi, you know, what's the difference? So there's a huge need for differentiation in that space. And in other parts of the world, the fintech industries have undergone some kind of IP war, and they have sparked a huge renaissance in the quest for software patents and, you know, stuff like that. So I'm sure that the reason why they've not started fighting each other is because, or at least fighting for a dominant space in the market, is because they're probably still fighting CBN and fighting SEC, you know. But I see 2022 as the year when we will see a lot more interventions in that space, in the sense that in seeking differentiation from the next fintech startup, you will start to find the weaponization of IP. I think another reason why why they're not so much in arms yet is because maybe some of them, the apps that some of them are built on, are based on this GNU Creative Commons, or you know, some kind of sharing license. You know, so there's also that possibility. So IP is of course an indispensable tool in to any business. As a matter of fact, I'm not sure if it was better. I forget who it was, but a very recent survey, I think about 2 years ago, of Fortune 500 companies showed that almost about 70%, up to 70% of their network is actually based on their intellectual property or intangible assets. You know, and that's a huge number. But when you look at if you were to review the financial statements of the average Nigerian company, you know, IP is probably something that you would not see. You know, and the truth of the matter is most companies are run on the basis of know-how and knowledge. You know, so we're in the knowledge economy. So knowledge should, to a large extent, represent the bulk of where the value is. So IP is a very, very, very important tool for businesses. And I would like to commend, you know, all the interns and their various presentations, I think there was clearly an effort to establish the importance of IP, whether it was the analysis of copyrights and trademarks and patents, industrial designs, businesses that use these intellectual property rights. And I think this would be a good point to probably highlight a distinction that I guess maybe confuses a lot of people in the public domain. The distinction between the intellectual property and the intellectual property rights. That was the MB Abuja branch chairman. So I am in very good company, whistling. If you heard the whistle. So, Chairman, please say hello, sir.
Hi, good evening, all.
Says hello, good evening, all. So, I was saying that there's this people, sometimes we use IP and IPR interchangeably. I think that is can be confusing to a lot of people. The IP is the IP itself, and the right is separate from the right. The right is a creation of statutes, or it could be a creation of common law or law of tort. So as a creation of statutes, you have copyright, trademarks, patents, industrial designs. Yes. And as a creation of the courts, at least in Nigeria, you have passing off image rights, publicity rights, etc. And so the intellectual property rights is separate and distinct from the intellectual property itself. So a company, for example, can take a loan from a bank and as collateral for the loan deposit a deed of assignment, because the Trademarks Act requires that in order for a transfer or transmission of a trademark to be lawful, there must be a deed of assignment. So they give the bank as collateral their trademark certificate, execute a deed of transfer or assignment, and also execute a deed of legal mortgage. In that scenario, the bank or the lender holds all the legal documents, that show or establish the IP rights. But the bank or the lender does not own the intellectual property. The brand, the trademark still stays with the company. The company still controls the trademark. It will be different from a scenario where the bank now takes a step, perhaps maybe in the event of a default, to register the assignment of the trademark. In that situation, they will now be said to have become the owners of the trademark, and then if they start to use it, then they can now be said to use the trademark. So the IP right is different and distinct from the IP itself. And the right is oftentimes a function of several composite units. So it includes the right to do so many things, and so on and so forth. I find, and so I just felt that it was important to clarify that point. So there are forms of intellectual property that exist that have no right, that are not situated within any right, and of course the common law, law of tort, law of contract, oftentimes tries to look for a way to protect these forms of intellectual property, but it is what it is, But at least the ones that are protected by law are the ones that we talk about: the copyrights, patents, trademarks, designs, and passing off, and so on and so forth. I think I took a particular interest in this. Is it University Challenge case now? I think that was an interesting one. I think the Court of Appeal has ruled. I saw in one of the presentations that there was a reference to the case where the Federal High Court Justice Echo gave a judgment sitting in Abuja, I think, gave judgment awarding some huge amount of money for the. I unfortunately I haven't seen the pleadings. Usually, what I do in these cases is I try to get what was filed, the statement of claim, and then the statement of defense, and of course the judgment, because it does help to appreciate, the arguments that were canvassed. But I think that that decision was reversed by the Court of Appeal. It is interesting. Most times, I think we tend to mix up a lot of things with copyright in this part of the world, and I don't know that I will absolutely agree with the decision of the trial court to award damages. Again, I haven't seen the judgment in full, but it would appear that the judgment is based on the apparent similarity between a proposal by one company submitted to NUC. I don't think that's how copyright is supposed to work. If somebody has a literary work, and that literary work is a proposal, you cannot, I don't think you cannot create a derived work from a proposal by executing that proposal. It doesn't make the way you infringe on a literary work, is by copying it. The primary mode of infringement is by copying or by doing any of the things that the author ordinarily has the power to do. So that may include printing, publishing, distributing, and by distribution, we're presuming that the first sale right has not been exhausted. So the author has the power to say, okay, this is my exclusive distributor, but only for the first, until that first right of first sale is exhausted. Once the right of first sale is exhausted, what's it called? The author cannot stop anybody from selling that book. I can buy the book and sell it, on the open market. So there are limitations to the ways in which certain types of literary works can be infringed upon. For example, let's say I don't know what books are used in schools these days, but when I was younger, Ugo was, I think was for physics or further maths or one of those science courses. And imagine that Ugo, that somebody maybe recorded a video and solved some questions from some physics questions that were posed in Ugo. Can Ugo claim that the person who solved those questions has created a derived work from his textbook? I would argue no, because certain types of books that are functional or have functional content, cannot be the subject matter of a derivative work, especially if it's like a work of fiction or a work of art. But it's different and distinct from a book like The Gods Are Not to Blame, or Olaro to me is The Gods Are Not to Blame, which on its own is based on the Greek concept of the Oedipus Rex, the boy who kills his father and marries his mother. So somebody can create or write a movie based on Olaro Timi's book, and the law will hold that, oh, this is derived from Olaro Timi's fictional work. So I don't think that a proposal, if someone writes a proposal, it's a literary work, like a textbook. Anybody who copies that proposal will be infringing. Anyone who prints, produces, manufactures, distributes the proposal will be infringing. But that doesn't stop anyone from, it doesn't stop anyone from executing the business that is in that proposal. So, and of course, what I would have probably expected would be maybe the university challenge person had gone to register a trademark for university challenge, and then was now contesting the Zen Africa challenge, and all that. Unfortunately, I think the Court of Appeal's reason for upturning the decision is also a little dodgy or suspect. Again, I haven't seen the judgment, but from what I understand, on appeal, NUC argued that I think they argued on the basis of statute of limitations, whether it was the Public Officers Protection Act, and the Court of Appeal overturned the judgment. So I think that was an opportunity that has been missed. I will take a little more interest in that case, just in case it has gone up to the Supreme Court. 703 million naira is not something you go to the Supreme Court for that. So I expect that University's challenge will probably go to the Supreme Court. But IP is important to business, as we can see. Imagine a judgment like that could bankrupt any company. It could make the board start reconsidering what the directors are doing. Make the shareholders start reconsidering what the executive directors are doing, and so on and so forth. So, having said that, it sounds like I've been on a very long monologue. I would like to end by saying that I think this conversation is very important, because you find that Nigerian entrepreneurs we don't tend to value non-tangible or intangible assets, and that's our manpower, our skills, know-how, and all that. I think the quicker or the faster we begin to realize that these are actually our most valuable assets, the better it will be for us, as a country and as an economy. So thank you once again for having me. Well done, you guys. I think you're just in the first, you're in your teething stage of the session. So I look forward to the time when we start cracking bone, and of course having much more engaging conversations. But I'm open. I'd like to hear your thoughts also, other thoughts on this topic. So thank you, Juliana, and thank you very much, Bernice.
Thank you so much, sir, for your robust comments. You've practically answered one of the questions that was asked. So I'll move over to the other questions. Okay, before then, I would like to ask if our other mentor that is around, Shukura Amusa, has any comments.
Hi.
Hello. Good evening, ma.
Can you hear me?
Yes, we can hear you.
Yeah, good evening.
So
okay. The mentees, they've done quite well, and Mr. Folarin is like, he has covered everything we have to talk about. So I don't think there's much thing to discuss. But I think I would like to touch on the copyright case he was talking about earlier. Just like he said, copyright is the expression of ideas. That you can't protect the ideas. You can only protect the expression. So for that case, that I think it was Group 3 that raised that case. In a case whereby that idea is not being expressed in a tangible form, then I don't really think there should be an infringement in that case. Because when it comes to copyright, you have to look at, is it the same thing? We can all, if you have an idea, the way you put yours will be different from the way I put mine, but we are still all building on that same idea. So did they leave, or did that other people that carried out the infringement, like they claimed, did they carry it out the way they wrote their plan or something like that? Then when we look at, there's another thing we need to look at, that is if those people have seen the idea before. So if they've seen the idea before, then you look at, is it similar? How similar is what they've done to what exactly those people presented? So I think that way they should be able to like arrive in a better judgment. So I think that's all I have to say. Then on group, I think that was group 2. Group 2, the presenter was kind of mixing up patents. She said we have different types of patents, utility patents, industrial or design patents, plant patents, and patent itself. So when it comes to utility patents are just like small patents, like small version of patents. That is, they are not as stringent, they are less stringent compared to the presentability for the normal patents. So when it comes to design patents, in this part of as in Nigeria, we don't really call it design patents. It's called design patent abroad, but we call it industrial design here. So that's just it's design patent over there because so over there you have to like present your claim. Unlike in Nigeria here, you really don't need claim like that, or because it's more like a design aspect. You're looking at the aesthetic nature of that design. So here we call it industrial design. Why they call it design patents over there? And when it comes to the plant patent, that's your new variety. It protects plant protection and breeders and farmers. So I think that's just the breakdown for that. Yeah.
Thank you so much. Thank you so much. Yes. So we'll go over to the other questions. So the first question that was asked was, can computer programs be protected under patents? If not, to what extent does a software need to be if not, to what extent does a software need to interact with a hardware to be regarded as an invention? So the question is directed to Mr. Folarin.
Thank you very much, Bernice, and thank you, Shukra, for the clarification. I think I see Shukra on Instagram from time to time doing God's work. Okay, so well, the answer is there an answer? So let's bring it down to Nigeria. I think while presenting the group that presented that spoke about, I think that's group 2, patents, mentioned that, said a lot about patents. And also, I think one of the first things that was mentioned was that patents are territorial. So I would agree with that. So any conversation about patents, patentable subject matter, generally, will be a domestic or a municipal or a country-based conversation. Why? Because the substantive requirements as to what is patentable or not varies from country to country, and it's pretty much based on what is acceptable in those countries. For example, I know that for several years in Japan, software was specifically mentioned in the Patents Act. In the US, there was a presumption, not a presumption. It has been argued. It's been argued that software patents were registrable, especially in the financial industry or industries that, where new products or new processes could be created or could evolve. And I think there's a case, Bilski, but there are arguments as to whether the USPTO would actually grant a patent for software simpliciter. That's just a software alone. Now, down to Nigeria. In Nigeria, the Patents and Designs Act is a very funny document, especially when you look at the definition of what is not, the definition of what amounts to or what can be patented. An invention is not defined, even though the Act tells us that an invention is patentable if it is new, the product of inventive activity, and is capable of industrial application. So let's look at those requirements. Novelty, new. Novelty means that it must not be part of the state of the art. State of the art includes the state of the art of technology all over the world. So it must be new. It mustn't be part of what exists. And of course, there are a few other requirements as to novelty. Inventive activity. So there must be, it should not be an obvious improvement or an obvious derivation of something that exists already. So it cannot be obvious, it must be non-obvious. Industrial application, it must be something that is functional. That's what industrial application means. It must be capable of being used in industry. So it's called the functionality the functionality requirement. Now that functionality requirement is what distinguishes patents from industrial designs. And industrial design is aesthetic. We say it's aesthetic because it has to just do with the look. So you can have a biro, even biro itself is industrial design. You can have a pen, that is designed like a square. It doesn't change the function of that pen. The purpose of that pen is to write, and because the purpose is to write, any new way or new look is just cosmetic in nature. So it's called a non-functional. So is that functionality is what distinguishes between patents and industrial design. And so you have all these three requirements. So let's compare software. So can you have software that is new? Yes. Even though people would argue that all software is written, through code, source code, and the language is not new, but you can have software that is new. Someone can write new software. We should also note that software, because computer programs are software, but the software is not what we see. It's not the user generated. It's not the user interface, the GUI, the graphic user interface. It's not the button. It's not the mouse cursor. It's the code that is running. So can we have new software? Yes, new code. Can it be non-obvious? So can somebody be inventive in writing new code? Yes. Can it be used? Is it functional? Can it create an outcome? Can it be used in industry? The answer is yes. Can it produce an outcome? The answer is yes. Now, we should note that patents don't, in Nigeria, both inventions and processes, so that's products and processes, can be patented. So because processes can be patented, I see a scenario in which many software may fall under the category of, process patents, because there's usually, even though we're not talking about the process of, let's say, producing honey from beeswax, just for as a random example, so the first question is, does software meet the requirements for patentability? I would argue yes. This is not an argument that is, I'm not supplying any authorities, but just by looking at the conditions in the Patents and Designs Act, section 1 of the Patents and Designs Act, I would argue yes. The other question, so the next question is, does software fall under the category of non-patentable subject matter, which include plant varieties, mathematical formulas, and things like that? The answer would be no. And when you now add to it the requirements or the caveat, I think in section 4, I think, of the Patents and Designs Act, where the Act states that once the formal requirements for registration have been complied with, the registrar has no business looking into examining or conducting a substantive examination into the is it not validity, but the patentability of that application. What that does is by taking away that requirement for an examination to find out whether, because what the examination does is, one primary thing that, or one primary purpose of examination is to find out whether what is claimed, whether the function that is claimed, or whether the device or what is claimed actually does what the patentee says the invention does. Whether the patent does what the patentee says it does in the claims. So it still goes back to that functionality. Of course, there are other reasons for examination, which also include checking for confirming that it's actually new, or that it meets all the other substantive requirements. So I would argue that because by that, with the combination of these factors, you can easily argue that software is patentable in Nigeria. And I have actually registered or obtained letters patent for a number of software applications, over the course of my short career. So my answer will be yes. I know that at a point in time it was not done. I also know that I have had to argue against refusals or denials in the past, and have the denials turned into approvals and then patent certificates. So my answer to the question will be yes. Now, but I wouldn't stop there. I would say, what then will the implication of this be? Because we should understand that patents are very dangerous things. They create a monopoly. Imagine that Microsoft drafted or filed a bunch of patents and drafted claims so wide that they could capture almost any word processor that is known today. What effect would that have on people who design word processors, or software designers or software developers who develop, other applications that may be similar to word processors? You understand? It may have the negative effect, or it may have the effect of actually stifling smaller developers or stifling innovation. In the I hate to use Microsoft, but it's not as if Microsoft is doing it or is not doing it. But I guess we get the point that a big player can use the process, file, what patent trolls do? They'll just file several applications. Once there's a new technology or there's wind of something new in the market, file patent applications, obtain patents, and then start to bully or force others who don't have the power to obtain the patent, or who are not quick enough to obtain the patent, force them out of the market. So I guess there are implications for allowing software to be patentable, or designating software as patentable subject matter. So I think that's a bit of my answer. So the answer to the question is it possible? Thank you, Steve. Good night. The answer to that question is yes. I think it's patentable in Nigeria. I don't see any reason why the registry, the Patents and Design Registry, should deny an application for software patent. However, what are the possible social implications? There's a balancing act somewhere in between, because I think it's section 4 sub 4 of the, again, I'm just shooting from the hip, but the Patents and Designs Act provides that patents are granted at the risk of the patentee without any guarantee as to validity. So in other words, your patent certificate is just a piece of paper unless and until you've gone to court to contest it and the court has upheld, the validity of that patent. So I think that's an interesting, again, it will be good to see how this plays out, in a real life scenario. And I'm hoping the fintech guys can give us a run for our money in this space. Let's see how the law will develop. But is it doable? Yes, I think so. Should every software developer run to get a patent? I think so, especially if you're looking at scaling your your application. What the effect will be is a totally different kettle of fish. And I'll leave that for our guys at the top, Juliana and Bernice, to decide.
Thank you very much. Sorry, Bernice, I would like to just quickly say something, if that's okay.
Okay.
Okay, so thank you very much, Mr. Folarin. From a practical experience, anyway, what I've seen in the past is that they're usually hesitant to grant software patents, and several times when I take stuff like that, they usually ask whether it's really solving a problem. That's even if they want to grant it, they might be asking you questions like, what exactly is this thing
They will
solving?
try and talk you out of it. They will
Yes.
talk you out of it. Yes.
But if you're able to convince them that it's solving a problem, then they might grant it. But towards the end of last year, so I reached out to someone working there, and she said that they have started granting patents for softwares and for business method. So that's for software, business method, and utility patent too. So I asked her if the new Patent Act has been passed and if that is why they are now doing it. She said she cannot really comment on that, but that they have started granting software patent, utility model,
Models.
um,
I can comment.
model.
Yes, utility models. It's because it's because the federal government is looking for money. And so now they've realized that, oh, by denying applications, we're not going to get any money. So just bring it, we'll grant it. Why? Because the Patents and Designs Act does not guarantee the validity of your patent. So until you take the patent and design registrar to court to say, oh yeah, come and tell the court that my patent is valid, and that's the interesting. So I think it's a bit of an economic, phenomenon. But yes, but in my opinion, there's nothing in the act from day one that stops the registry from denying, or that allows the registry, empowers the registry to deny these applications. And yes, I agree with you that there will be many attempts to talk you out of it. They say, but look at, and then you just have to keep it. But, again, that industrial application, I think there's a huge amount of confusion about what it really means. And it's not a Nigerian phrase, industrial application. It's actually a very old phrase. It's a carryover from, I think, the 1800 Patents Act, which was a statute of general application. And what it essentially means is that it must be useful. It's functionality. So if you're saying that you have invented a microconductor or semi-microconductor chip, does it do something? Does it do what you are saying it does? What it does not have to be useful. It may even be useless, but does it do something? Is it functional? And if the answer is yes, then it meets that criteria. So, but what one finds is that maybe they may ask, does it produce a result? It doesn't have to produce a result. It must not necessarily be an outcome. The question is, does it do something? And if the answer is yes, then I think it meets that industrial application.
Okay. I also wanted to say that there's someone from Kenya here, Mitch. So I don't know if he can also comment what it's like in his country if software patent is also granted there. Hi, Mitch.
Hi, how are you? I'm from Kenya. To a question, we face difficulties registering patents in Kenya as well because, like you said, they don't see how the software will solve a problem. So they make it difficult for you to register a patent. And it takes like roughly 2-3 years before a patent is actually registered. So by the time the registration process is done, the software has been upgraded and they start asking you questions of, is the modification different from what you applied for in the beginning? So we face difficulties as well. And so far, I have not registered a patent software. So the same difficulties I think we're facing as the same as Nigeria.
Okay, thank you, Mitch. Over to you, Benis. Thank you.
Thank you very much, Mitch, for that intervention. I should also say that South Africa also has a no examination provision in the patents law, but a patent certificate is prima facie evidence of validity. So I think that's one major area where South Africa differs from Nigeria. I also understand that I think there's a move to to transition South Africa from a no examination to an examination based jurisdiction for patent applications. So just thought to put that out there.
Okay, thank you everybody for your contribution. So we'll move on to the last question for today. So how does trade secret lead to the development?
Please, can I add something to what I've been saying?
Okay, yes, you can.
Okay, I think I'm going to look at another direction for mine. If we look at intellectual property, most of these intellectual property, they have kind of overlap. If you look at copyright overlaps with industrial design in a way. Copyright overlaps with patents in a way. Trademark overlaps with geographical indication in a way. So the best bet is for you to look at your business strategy properly. Then look at whatever it is that, look at the intellectual property rights you want to protect. Then go for the best that suits you. You also have to look at the duration, look at the timing. This is my intellectual property. Would it last for long? Is it something that is possible to stay in the market for a very long time? So you look at that and you pick a very suitable protection that is going to protect your intellectual property. So going by copyright and patent, for a very long time in Nigeria, they don't usually register software with patents. Is majorly on copyright, because when you look at the patentability requirements, you look at the is it new? And if you notice, most of the software these days is just slight improvements. They actually kind of do the same thing. And because it's an open source is where this one can come here, you take something from here, take something from here. So you take something from an open source, you now say you want to go ahead to patent it. It's not, that won't work. So you look at that criteria. Is it new? Is it industrially applicable? Then another thing is, does it have an inventive step? So I think the problem lies with having an inventive step, because if this thing is just a slight improvement, the inventive step might be very obvious to someone that has a knowledge in that area. So you look at it, if it's something that is not obvious, that means the inventive step is okay. Then you look at if it is mass produced, that if it is industrially applicable. So if you look at copyright in the other aspects, copyright does not really have so much criteria, because the formality is not much. Once you have written this thing, you know it's copyrightable. But just for infringement cases, you have to protect it with NCC. So I think copyright is less stringent, and that's the more reason why it's advisable for you to protect your computer program with copyright. Then looking at patents, you look at the advantages and disadvantages. For patents, you have to disclose your idea, and it's just 20 years. Compare it with copyright. Copyright, you really don't have to disclose it that way. You just have to have it in a tangible form. Then look at the timeline for copyright. So if you look at the timeline for patents and copyright, you see copyright is more preferable compared to patents. Then just like what Mr. Folari has said, validity. In Nigeria, we don't do substantive examination. We only do formality examination. And that means they don't check your work as to substance. They only check your work as to formality. The format, is your title there? Do you have description? Do you have drawings? Do you have claims? That's what they check. They don't check what exactly is it you are claiming. They don't check if somebody else has something in this area. So that means you getting a patent application registered. You're not even sure if in future somebody will not come and say, this work, I have something related to this. Do you understand? So just stay with something that you know, okay, at least to some extent, will protect you compared to going for patent. So both patent and copyright is applicable, but just look for the one that suits your business properly. Thank you.
Okay, thank you so much, Amofa. So I'll go on to the next the last question for today. How does trade secret lead to the development of IP itself, considering that it is not to be disclosed? So this question is directed to Mr. Folari.
I don't know, Dennis. I think it's a secret. So I guess it's a secret how trade secrets leads to the development of IP. Well, we already agree that not all forms of, it's not all intellectual property that can be protected by existing intellectual property rights, and I think Shukra said something that, I would piggyback off, which is that at some point, you must have a strategy. So I think this is one thing that lawyers actually, well, IP practitioners, because IP practitioners can provide clarity to clients for, and that is in the area of helping them develop a strategy. So you have an intellectual asset, you would want to determine, okay, what right better protects or best protects this type of intellectual asset. And one of the things you look at, just as Shukra said, is you look at, what's the duration? How long will it last? I think patents are actually the most powerful of all the intellectual property rights. And if you look at the US Constitution, it talks about copyrights and patents. Copyrights emerged first, but before copyright, there were monopoly rights, all manner of monopoly rights. All manner of monopoly rights and charters that were granted. And so you could argue that those were like the precursor to the modern day patent. Patents are extremely powerful, but then copyright lasts longer, and even it extends beyond the grave, till after the death in some instances of the owner. So I think that's the first step. But then in some circumstances, you might just discover that, look, this patentee may not pay me, and neither will copyright, because in either case, if let's say you're in the US, in the United States, for example, you have to register your copyright for it to be actionable, to sue for infringement. In which case, you would make a disclosure. With patents, you must show you're working, as they say in university or in primary school. Show us you're working. Don't just give us the answer. We want to see how you got to the answer. So in either case, disclosures are made, and it's one of the trade-offs, in exchange for the monopoly rights that come with IP protection. So you could write the most beautiful poem and keep it under your bed, and no one will ever read it and will ever be touched by it. It has no value, IP valuation, hashtag. And so the question is, how do trade secrets contribute? Well, not every, I don't know, we famously talk about the Coca-Cola recipe. I don't think it's really a secret per se anymore, because there are many ways you can reverse engineer, and a lot of people have done it. They reverse engineered the Coca-Cola, the Coca-Cola taste. And the truth of the matter is, I'm sure Mitch will tell us that, if we ask Mitch, what does Coca-Cola taste like? He might tell us, oh, it's a little sugary with a tinge of cola. And then if we ask Juliana, what does Coca-Cola taste like? She might say, oh, it's very sweet. If we ask a Gambian, what does Coca-Cola taste like? Say, oh, it's really sweet. So Coca-Cola has different tastes in reality. I think the myth of the trade secret has been used to sell the brand much more than to protect the recipe, considering that the recipe was actually purchased from the pharmacist. But the question is, how do trade secrets help? The trade-off of, I don't know whether we can call trade secrets intellectual property, an intellectual property right per se. It's arguable, because trade secrets are, first of all, you have to keep it secret. I mean, secret is in the name. But more importantly, you can only enforce a trade secret against a limited number of people. And it's often against people with whom you have had, interactions, with whom disclosures may have been made, or who have gotten, who have had the opportunity to access the secret. And so what that does, so I don't know, to my mind, it's a little dubious, to just refer to it strictly as an intellectual property right. A trade secret is not intellectual property. Intellectual property is the secret. Trade secrets are the intellectual property right. And is there any value in keeping something secret? Well, they are the only one that will know, and I guess what it does is that it increases the value of the intellectual property. And I'll explain. I didn't want to, let me just try and be brief. Or should I stop there?
No.
I want to read the room so that I'm not just rambling to myself.
You can go on, sir.
Okay, thank you, Bernice. So the idea of value is built on value. We had said earlier that value can be subjective, but there is an objective standard of determining value. The idea of value is actually built. There are a number of components that economists use to determine what is valuable. And scarcity is a very critical function of scarcity and demand. So when the more scarce or the scarcer something is, the more valuable it is. There are exceptions, and I will say that air is one of those exceptions. Air is not scarce, and is extremely valuable. But trust me, one doesn't know how valuable air is until one is gasping for oxygen, or one has just come back from a very hard run. But back to the point, gold is valuable because it is a scarce natural resource. Same thing with silver, and so on and so forth, to the nth degree. So in the same vein, if a valuable development or a valuable idea that has been expressed is shown to someone and is shown to have produced a result or an outcome, that actually creates something positive, whether it's in the mind of the person who is being pitched or wherever. Yeah, you can demand a higher value or a higher price for it. So the fact that the individual does not get to disclose to society, because that's the main trade-off really that that is used to sell intellectual property rights, or registration of intellectual property rights, that if you disclose, then you get protection. But in some instances, disclosure may be detrimental to the business strategy of that organization. And they may decide, okay, instead of releasing this software, for example, I am aware that there are algorithms that can compress very large files into very tiny file sizes. We already have those algorithms. The MPEG, the Motion Picture Engineering Group format, MPEG 4. Before MPEG 4 came out, you would have short videos that will be in AVI format, the audio, the AVI format, very large, 700 megabytes, 1 point something gig, 2 gig, 3 gig. But now with the MPEG 4 format or the MPEG 2 format, you can compress these videos to just a couple of megabytes. But I understand that and this technology had existed long before the formats were released, to the general public. I understand that there are also algorithms that can compress large, volumes of data into very small data sizes, but they're not accessible to the general public. There are some people who are already rocking those things and enjoying them and using them. So for those people, it's secret and is valuable. They're able to trade with it, in whatever ways that they wish to trade with it. So yes, trade secrets can add to, can provide value, but the problem is that it's a secret. So how do you reflect it on that company's balance sheet? It may be difficult. And of course, that the more pitches you make, the more non-disclosure agreements you have to sign, and the more people will actually learn about that secret. And so it may not be as secret as the secret of the Coca-Cola recipe anymore. So there is some value, I think, to be had from trade secrets, although the general public benefit of disclosure, is will not arise. The value might be tangential, and not direct, because there's no actual disclosure. I hope that makes some sense.
Yes, sir.
Yes, sir. Sorry, I just think I should add this. Like, I think part of the reasons why we have intellectual property rights is for people to benefit from their creation. So trade secrets too is for people to be able to benefit from what they have created. So I don't really, so I'm just trying to go back to the question, but if someone can write a book or sing a song and demands to at least not be deprived of enjoying.
But why should you want to listen to a song alone? Only you write the book, only you want to read it, only you.
No. That is why you are putting it out, so that you can get the economic benefits from it. So if something is not preserved via the trade secret, like using an NDA, etc. and all that, then you might not be able to benefit from that thing that you can profit from economically. So I think maybe that's how we should see it or something. Thank you.
Thank you, Juliana. I was just teasing you, but there's a story. I think is the Stradivarius. I'm sure I must have modeled that. The Stradivarius violin. This gentleman, somebody I think purchased all the violins, all Stradivarius violins, and kept them somewhere. And just palmed them there, and did not want anybody to hear or listen to music produced by this fantastic instrument. And I think most of these, they were lost for a long time until I think someone found them. I read that a very long time ago. You must forgive me. But why write the most beautiful piece, of music that the world has ever heard, and then just keep it under your pillow?
I think it's about someone being confused about the right protection to use. So if you have something like that, then you should be able to talk to a lawyer to know the type of protection that is
Juliana
needed.
is marketing. I agree with you.
No. His own. He didn't need to use the trade secret model because that is not what he's supposed to use to protect that. But for your client list, you don't have to take your client list to go and do a copyright registration and all that.
Yes.
You can just keep it secret. So you have to be knowledgeable about the type of protection that you need for your business.
My hand is up. I think Mr. Folari is anti-trade secrets.
No, I'm not anti-trade secrets. I'm just throwing up ideas.
Yes, I understand.
Yes.
I understand. But I think that's the more reason why people need to know about intellectual property and look at the one that best suits them. For example, you were talking about a creator keeping the book somewhere. For creators, you actually won't advise creators to use trade secrets because trade secrets are actually not meant for creators. It's more of the commercial industry whereby you need to give somebody an information and all. So a trade secret is just to safeguard the information you are giving out. But on the other hand, all intellectual property has their advantage and their disadvantages. So just like trade secret now, it has a wide advantage, but the disadvantage is what's it called now? If somebody does the same thing you are doing and the person go ahead to patent it, my brother, you just have to stop using that again because somebody has actually come outside and say this is it. So you will be the one infringing now and not the person. So your trade secret can be reverse engineered. If somebody should reverse engineer your trade secret and come and finally get that trade secret, you can't say that person is infringing on your rights. So they have advantages and disadvantages. So some people, instead of using trade secrets, they'll rather use patents. But on the other hand, trade secrets, if you are fine, able to keep it secret, then you have like your indefinite protection. But unlike patents will protect you for a good 20 years. And if you make a very good use of that, you have your value for it. So they all have their advantage and disadvantages. So know these IP rights and know the one that works best for your industry. I think that's what I'm just going to say. Thank you.
Thank you so much, everybody. So we've come to the end of this session. Thank you so much for the presentation, intervention, and comments. So I'll hand it over to Ms. Juliana for a vote of thanks.
Thank you very much, Benny. So for everyone here that needs like a fashion superstar lawyer for what they are doing, the person to talk to is Benny. So I don't even understand why she has not been commenting, because she helps a lot of people, celebrities in the fashion industry, to secure their rights. Possibly she will be invited one of these days to come and talk to us specially. So please take her name, take her handle, and find her on social media. So I'd like to say a very big thank you to everyone, especially Mr. Folarin. When there's like child, then there's father, then there's grandfather. So like he is like my mentor, then like that. So he's like a very special person to us. He's very supportive, very understanding, and very knowledgeable about intellectual property. So I encourage everyone, if you are looking for someone in the industry that you can talk to, he's one person that you can always reach out to. And to Shukurat, thank you very much. She was a mentee in the fourth quarter last year, but she's clearly very, very intelligent and knowledgeable about IP, and we are very happy to have her in this quarter. And for anyone here who pushes their work and is able to do very well in IP, you can always sign up to be a mentor in subsequent sessions. So thank you very much. I'll be sending you your assignments for next week. Have an amazing weekend, everyone. Good night. Bye.
Thank you, Ma.
Thank you, Ma.
Thank you. Good night. Bye.
Thank you. Bye. Good night.